Freedom of expression is a right that is constantly challenged in the Sri Lankan context for past few decades. But the voice that was raised against it was mostly of journalists, activists, and the minority communities. But in the current context, we see the public in general asking what freedom of expression is, and our right to freedom of expression is violated. But do we really know what this right is? And do we know what is the redress that we have in terms of it getting violated? To serve this purpose, we have initiated a series of interviews. In today's episode, we have Mr. N.K. Ashokbaran joining with us. He is an attorney at law and he works in constitutional law and administrative law. We warmly welcome you to the program, Mr. Ashokbaran.
Hello, Sajini. It's a pleasure to be here.
So tell us a bit about the scope and the limitations of freedom of expression in the Constitution of Sri Lanka.
Our constitution explicitly recognizes freedom of expression in Article 14(1)(a), which also says, which includes publication as well. So when you say freedom of expression, the immediate thing that comes to our mind is talking. So that means you can say whatever you want to say. However, we have seen that that is not the very limitation of expression. You can express with an art form. You can use placards, and of course when it's a publication, it's not publication of a book or a newspaper, it can include pamphlets. So wide variety of ways are there for human beings to express. I mean, sometimes in protest when you raise noise, that is also a form of protest, a form of expression of your opposition to something. We see our political parties sometimes ask people to horn, use their vehicle horn, make noise in maybe when the price of fuel goes up. Now, that is also a form of expression, and our courts have recognized that when you say freedom of expression, that includes this wide variety of ways of expression as well. So it's not merely limited to words written and said. On the other hand, if you ask me whether this right is absolute, that means you can say whatever you want and get away with it. Well, that is not the case. Like many other countries and many other jurisdictions, freedom of expression is not an absolute right. It has its restrictions. When we say restrictions, we speak of two kinds of restrictions. One is statute law or statutory or constitutional limitation. Other one is common law limitation. Now, when we speak of common law limitation, there is a very famous United States judgment, which is often referred to in our judgments, that is of Justice Wendell Holmes, wherein I believe the case is Shenek versus United States, where he said your right, freedom of expression, does not include the right of a person to walk into a theater and falsely scream fire and thereby create chaos and make people panic. But if you ask me whether that common law limitation applies in Sri Lanka, despite in several cases, including landmark cases such as Malavarachi versus Malavarachi against Seneviratna, and Channapiris against Attorney General, Bernard Soisa against Attorney General. In these cases, the learned judges have quoted this dictum of Oliver Wendell Holmes in their judgments. However, the question whether this common law restriction applies in Sri Lanka is yet to be decided, or rather yet to be interpreted. However, our constitution introduces a certain limitations, so our constitution gives way to impose certain limitations on the freedom of expression and other freedoms as well. The main provision, I would say, is Article 15(2), where the freedom of expression can be limited by law, prescribed by law. That means it cannot be limited by an executive action. It can be limited only by law, that is Parliament by passing a law for certain reasons prescribed in that, which includes the rights of others. Now, that is very important, and of course parliamentary privilege, contempt of court, defamation, which means you can't make a statement defaming another person and claim, yeah, that's my freedom of expression. So those limitations are provided for in the Constitution, and of course there is Article 15(7), which says where by prescription, by law again, for reasons such as national security, public health, public morality, and of course there is a very odd wording which says to uphold democratic or welfare of a democratic society, the fundamental rights can be restricted. Now there is quite a difference in our restriction clauses compared to the restriction clauses in other countries, where here the parliament can impose a restriction. It need not be reasonable or necessary. So such fetter is not imposed. So say in comparative jurisdictions you will see these restrictive clauses being there, but then it will say that when it's needed, when it's necessary, and it must be reasonable. So such fetters are not imposed in our constitution. So which means the parliament, as it may deem fit and needed, can impose restrictions under any of these categories, and especially when you say to maintain the welfare of democratic states, and especially this defined as a national security issue. So those are the limitations or restrictions on the freedom of expression.
What kind of international obligations Sri Lanka has as a country to uphold freedom of expression?
I think the UDHR, the Universal Declaration of Human Rights, in Article 19 recognize freedom of expression, and of course the same article, similar article is there in the ICCPR, Article 19. However, ICCPR recognize the limitations. Most of them are similar to the limitations which are imposed by Sri Lanka. However, we go one step ahead, and when we speak about the maintenance of this democratic welfare values, and that part is an addition. And of course, our ICCPR Act also makes it an offense to say things or do things with which could incite ethnic or religious violence or discrimination or disharmony. Which also I think our penal code has certain penal provisions where it lists out offences against religion in 290 and 291 A and B. So the restrictions, of course, on fundamental rights is universally recognized. ICCPR recognizes that. So that is in theory. However, in practice, how those restrictions are imposed and for what purpose is quite an interesting thing to look at. Now, as I said earlier, in some countries, when the restrictions are imposed, it has to be reasonable, it has to be necessary. So the government or the legislature which imposes that has a burden to prove that, to show that this was necessary or this was needed or this is reasonable. However, our constitution does not impose any of those fetters, which in a way gives very strong power to our government to restrict these fundamental rights when it deems necessary. It might not actually objectively be necessary, but it has become a subjective thing. So that is one worrying aspect in Sri Lanka compared to restrictions. I mean, of course, freedom of speech cannot be absolute. As I said, no one can have a right to defame another person, or no one can have a right to perhaps say incite violence, perhaps incite religious and racial disharmony. Even the United States, which has a which is very stringent in restricting their First Amendment right, we see intellectual property has been violating intellectual property rights has been an exception, and of course pornography, obscenity, and even child pornography, very seriously, they don't include in freedom of expression there. So these exceptions are universally recognized, and they are needed when it comes to freedom of expression. However, as I said, when we say they are needed, that points to necessity. So our constitution should ideally include such a fetter where these restrictions can only be imposed when it's necessary and they must be reasonable and perhaps proportional as well.
When you mentioned of the ICCPR Act in Sri Lanka, I think we say that it is being used to impede the freedom of expression in the country. What are your thoughts on it?
Of course, because it imposes a restriction, and again, it gives immense power in the hands of the government to or the prosecutor to decide how to use it. As I said, I mean, this is a law. A law is a sword. So you give that sword to the government, and you expect the government to defend the rights of the citizen. And sometimes, unfortunately, the governments use that to offend the rights of the citizen. So that is a danger which we have to look into, because if you look at ICCPR Act Section 3, it is for a specific purpose to prevent use of speech or expression or action which would cause ethnic religious disharmony and ethnic or incite religious ethnic violence. So I, like many others, have wondered why this act has not been used in cases where it could very reasonably be used, and why it has been used in cases very obviously it should not have been used. So that goes down to the question of prosecutorial discretion, and I believe that discretion is arbitrarily, capriciously, unreasonably, unfairly exercised. So it is not to blame the law, but to blame the people, or rather the prosecuting power, which is abusing that law.
How important is freedom of expression to journalists and activists, especially in the current context?
Absolutely important. I would say it's absolutely important. It's one of the foundational rights for journalism, which we say is the fourth pillar of a democratic state, because the idea of a democracy is where citizens, including journalists, of course they have an elevated role in their professional capacity, but citizens have a right not only to express but also to receive information. Now this second part is very interesting. I think in Sri Lanka there's a very interesting case. I believe it's Justice Mark Fernando's judgment in a case against the SLBC filed by a listener who filed that case because SLBC decided to abruptly discontinue a program where the listeners also can participate and get information. And the Supreme Court held that that abrupt, arbitrary discontinuation, that program violated the freedom of expression of that listener. Because as citizens, we have the right to express and also to receive information, that is through free media, free press. So free press is foundational to any democracy, not just vibrant democracy, but to any democracy. So freedom of expression is the one which gives that power to the media, that freedom to the media. So I believe freedom of expression is inevitable, or sine qua non, if I have to put it in the Latin jargon used by lawyers. It's an inevitable need for any democracy.
In terms of getting freedom of expression violated in Sri Lanka, what kind of remedies that the citizens of the country have?
Of course, we have two. When we are talking about violation of fundamental rights, we have two major remedies. One, the main remedy is filing a fundamental rights petition to the Supreme Court under Article 17, read along with Article 126 of the Constitution. But there is a time limitation. Any citizen whose rights are violated must apply to the Supreme Court by way of petition within 1 month from the date of that violation, or from the date where that citizen became aware of that violation. So this time bar is mostly almost always considered mandatory. There have been very limited exceptional situation where in situations where the particular person was prevented from coming to court within that time bar, or he could not come within that time bar due to reasons beyond his control. So that is the major remedy going to the Supreme Court, because the Supreme Court is vested with very wide jurisdiction when it comes to remedy under the fundamental rights jurisdiction vested on it. The alternative remedy, of course, is going to the Human Rights Commission, which is easier and which is more accessible because the Supreme Court is only in Colombo, especially for people in the outstation where they could not come to Supreme Court within 1 month or follow that time limit, or they have like continuous difficulty to come and file a petition in the Supreme Court. They can of course go to the Human Rights Commission, which I believe has branches in different parts of the country as well, and lodge a complaint, and there can be an inquiry held, and the Human Rights Commission will is bound to hold an inquiry and give a recommendation. So there were questions about whether the recommendations of the Human Rights Commission must be followed, because there have been instances where those recommendations have not been followed. However, recently we see a trend where the Court of Appeal issue writs of mandamus mandating the authorities to whom the recommendations are made to follow those recommendations. So that move by the Court of Appeal has actually strengthened the recommendation of Human Rights Commission, and altogether the process of complaining to Human Rights Commission and obtaining redress from them.
Thank you very much, Mr. Ashok Baran, for joining with us today. It was a very enlightening discussion, and we will meet you again with another episode of Janatavat Vedikawa.